just the one. Okay, so we are here. Where are we? Thursday, February 3rd. Groundhog saw his shadow yesterday, and as a result, we've got a major snowstorm outside today. So I've been having a little bit of trouble with my internet being a little bit unstable today. If something happens, I apologize. I have a feeling that has something to do with the storm. Ordinarily, my internet is pretty stable, but whatever. All right, let's see where we are. We're going to start chapter 20 today, occupational safety and health. Hopefully you guys enjoyed the lecture on Tuesday for ERISA, the Employment Retirement Income Security Act. That was well in excess of what the book had on that, but I think it's a pretty important area. So I think it was worth me sharing my additional insight above and beyond what the book had. So today we're going to talk about occupational safety. Occupational safety is one of those things that, once again, is an employment law that gets added to the history of the United States at kind of a late date, if you will. I believe OSHA, the Occupational Safety and Health Act, was in the 1970s. I think it's in here, but I didn't see it. But I think it's also from the 1970s. So it's not something that is extraordinarily old. And it is an attempt by the government to try and create a right to a safe working environment. I don't know about you, you could do a show of hands if you wanted, but realistically, in my mind, I don't think that I want to have a job where there is a good chance that I'm going to be killed at work today. I don't want to have that kind of a job. And I don't think any of you do either. You want to have your opportunity to die in an industrial accident be something that's rare. You don't want it to be something that's common. If you go back far enough into the history of the United States, you're going to find that it was a lot more common than it is today. One of the reasons that it's not common anymore is because of the fact that the government stepped in and said, we need to start thinking about how to create a safe work environment. Now, when we talk about safety, it's safety and health. It's not just Safety Act. It's the Safety and Health Act. Because in addition to workplace accidents, there are also other concerns when it comes to your safety at work. And many of you may know about this, but for example, if you work in a factory where there are noxious chemicals and fumes constantly around, there are plenty of workplace illnesses that are created by chemicals and gases and whatnot that you encounter in your workplace. Okay, the easiest example of this is black lung for the miners, the coal miners. They had a whole particular disease that came about purely because of the fact that we had the miners working in the coal mines and breathing in coal dust for years and years and years, and creating a lung disease, which is referred to as black lung. And it is basically something that comes from working in a mine. So as a result, we have plenty of workplace illnesses that also exist out there. Okay, so it's going to come down to the government trying to force the employer to make everything as safe as possible, whether it's to try and prevent injuries from illness, or whether it's to try and prevent injuries from workplace environmental problems that can give you an illness as opposed to an injury. Both of these are covered under OSHA. And both of these types of things are to be dealt with by the employer. The employer is tasked with making the workplace environment as safe as possible. you guys know that my son's been in the hospital, and one of the interesting things that we had going on while he was in the hospital, the room that he was in for the last 2 weeks that he was in the hospital, overlooked a construction site right next door to Presbyterian Hospital in Pittsburgh. UPMC is building a new building, so it's this. I think it's probably around 11 stories. My son's room was on the 10th story of the hospital, so we could see pretty much where the top of this building was going to be. And it was interesting watching the workers work on this new building. The new building, the superstructure was up, all of the steel was in place and welded and bolted in place. It appears that the floors, all of the individual floors, let's call it a 10 or 11 story building, all of the floors themselves were poured concrete and such, because you could see that people were walking around and working. It was wrapped in plastic, so we couldn't necessarily see in because of the cold weather. They wrapped it in plastic so they could keep some sort of the weather out and the heat in for the workers. But what was most interesting were the workers who were working on the outside of the building, because we could see them. They were pretty much basically, I want to say 10 or so feet away from us, because the buildings are not that far apart. And we were watching them. They were the workers that were working on the outside of the building. And basically what they were doing was putting up the supports that were going to end up holding whatever the skin of the building was going to be, whatever the actual facade of the building would be. They were putting up these metal studs, so to speak, up the length of this 10 or 11 story building to give them something to screw the skin of the building onto. And they were in a huge lift device that could take them up to all the way to the top of the building. It was a basket type thing, and 2 workers could be in that basket. We saw them, dragging small connectors up in there and screwing them into the side of the building. And then we would see them bring the big long pieces of, I think they were more aluminum than steel, because this wasn't going to be structural. It's going to just hold the skin on. So they appeared to be like 20-foot long aluminum studs that got screwed to those installation brackets that they had put on earlier. We didn't stick around long enough to see them actually attaching any of the skin to the building, just these supports. But the interesting thing is you could see OSHA at work. Okay, because if you think about these people, there's a number of dangers that you can encounter in the construction industry, and these people were, a good 100 feet or so in the air in this lift machine, and one of the big concerns that you have in an environment like that is a fall. Right, a fall from a distance is going to be probably deadly, right? So if you were to fall off the top of that building, or fall out of that lift machine when it's all the way up at the top of the building, you'd have, like I said, probably a minimum of 100-foot fall, and that would probably be enough to kill you. I think it would be enough to kill me at least. But there were a few things that I found, and I'm aware of these as being OSHA standards. But for one thing, the people that were in the lift machine, okay, so it was a basket that was wide enough to hold 2 workers. There was a remote control device, a joystick, so to speak, that allowed one of them to control the machine as far as to height and moving it left and right and back and forth, so they could get the machine, the lift, into the position they wanted it, so they could be where they wanted to be in order to do the attachments. But the biggest concern there is the fall concern. And so what you would see is every one of the workers that was in that basket, they had a harness on that went over their shoulders and around their waist and under their legs. And that harness was attached to a lifeline that was attached to the lift machine. Now, if the lift machine was going to fail, they were going to die. But basically, if they fell out of the lift machine, they wouldn't go anywhere, because they would drop to the extent of the length of the lifeline, which I'm sure was not more than like 6 or 8 feet. So although it probably would be uncomfortable hanging from that until you could be rescued, you weren't going to die. You could also incur some sort of injuries, I'm sure, bruises or contusions, and possibly even broken bones. But once again, you're not going to die. All of the workers that I saw anywhere at height had those harnesses on with the lifelines attached to something. Sometimes there would be a worker that would be facing out from the new building to work with the people that were in the lift bucket, and you would see that the person who was working on the leaning out of the building, he was basically on concrete on an existing building, but he was leaning out into the open air. He had a harness on. I have no idea where it was attached to, but you could see the lifeline that was attached back somewhere behind him to the building itself. Another thing that I saw very specifically was on the roof, at least, actually on every one of the floors, there were also barrier wires. So realistically, if somebody were going to accidentally get too close to the edge, and there was zero danger of them accidentally stepping off of the building and falling to their death, there was a wire that was stretched across any opening that led to a great fall. So once again, that was OSHA at work. Okay, so when OSHA identifies that there is a danger that could injure or kill a worker, they're going to put in rules about what is required. So those harnesses that I was talking about, they're canvas straps, basically thick enough so that they're not going to bite into you if you actually do fall, and they go over your shoulders. They connect at the waist, they around your shoulders into the back, front and back, and then underneath your legs, so that if you fall, you're going to be suspended by this harness. So OSHA puts in a rule that anybody that's going to be working at any height is going to be required to wear a harness with a lifeline attached to it. That's fine. That's wonderful. It's that's very smart. It's interesting, though, the number of people that don't want to wear their safety harnesses. I've had a number of clients over the years that were in the construction business. I had one who tried to specialize in windows, doors, and roofs. And so he would have roofing crews to put roofs on a customer's house. Roofers are supposed to have harness, lifeline connected to something to keep them from falling off of your roof to their death or injury. Very few of this particular client of mine's workers wore a harness. They felt that it slowed them down. Sometimes what you have is you have people that get paid piecework as opposed to being paid by the hour. So sometimes you have people that are just very much in a hurry, and they don't want to take the time to do the safety features that are required to keep them safe, because they know better. They are good at their job. They are not going to fall. This is a waste of my time. Get out of my face. Well, that's what they would tell you. Okay, but they do fall. They do get injured and killed. If you are an employer and your employees were not following the appropriate OSHA safety rules, OSHA is coming after you. Okay, this particular client of mine, he had a tendency to let his workers work without their safety equipment, without their safety harnesses, and as a result, OSHA knew who he was, and OSHA would go looking for him, because OSHA conducts investigations and inspections. And if they come and inspect your work site, and your work site is not safe, if you are not using all of the appropriate safety features, then OSHA is going to come down on you. OSHA has enforcement authority to enforce their rules. And how do they enforce their rules? Well, I guess they could put you in jail. I think there is the possibility of jail time if somebody is killed. So if somebody is killed and they're not, and you weren't enforcing safety rules, I guess there is a possibility that you could be convicted of negligent homicide. But the biggest type of enforcement that OSHA does is fines. Okay, they'll come, they'll see that you have these safety violations, and they'll just fine you for each and every one of your safety violations. The reality of it is that OSHA would much rather you be safe than collect those fines. They don't want to issue fines. They want to find a safe work environment, but they realize that the only way they're going to get your attention as an employer that doesn't care about safety is to fine you. And one of the things that we find in the world, you know, if you had me for for business law, one of the things we had talked about is if you have a corporation that is committing the crime, how does the government punish that corporation? It's difficult to put a corporation in jail. You're not going to put a lock on the front door as if they were in jail. So what does the government do? They fine the company. So you could end up with a fine. One of the things that we criticized back in business law was that fines, you know, a $100,000 fine to a multi-billion-dollar corporation is less than pocket change. It's less than petty cash. You know, it's not something that's going to get their attention and cause them to even care. Okay, and that's why, you know, in business law, we had talked about the fact that there should be a sliding scale so that the fine could theoretically be big enough to get the attention of the larger corporations. OSHA has the opportunity, has the chance of creating some very, very, very large fines. Now, the client that I'm talking about, that was the roofer. He was basically a one-man operation that had a number of employees or subcontractors, depending on how he was playing at that particular day, that worked for him. He was not this huge corporation. He was, you know, being honest, a relatively fly-by-night company. He ended up with a $75,000 fine from OSHA because he wasn't enforcing the harness rule for his roofers. $75,000 fine to this particular fellow was, it opened his eyes. You know, it made him sit up and take notice. In the end, he didn't end up having to pay the full $75,000. OSHA is willing to negotiate on fines if they believe that you have seen the light and you're going to change your ways and you're going to start enforcing safety and you prove that you're on the right path. They are more than willing to negotiate those numbers down a bit. Anyhow, that's how OSHA tends to work. So let's take a look at what's in our book for this this chapter. Some interesting things. Some interesting things when we're talking about reports from the Secretary of Labor. I found this is on the first page of the chapter. We're encouraged by the reported decline in incident rates for workplace injuries and illness, which is reflective of the joint effort of government, business, unions, and other organizations. Nevertheless, 3.1 million injuries and illnesses in the workplace is too high. Serious injuries and illness can knock a working family out of middle class. Workers should not have to sacrifice their health and safety to earn a paycheck. We remain concerned that more workers are injured in the healthcare and social assistance industry sector than in any other, including construction and manufacturing. And this group of workers had one of the highest rates of injuries and illnesses at 5.2 cases for every 100 workers. The Department of Labor's Occupation Safety and Health Administration will continue to work with employers, workers, and unions in this industry to reduce these risks. Illness and injuries for the public sector workers also continue to be alarmingly high at 5.7 cases for every 100 workers, which is more than 60% higher than the private sector rate. We must continue to work with state and local governments to ensure the safety of our public employees. So this is just a report that was given out in 2011 by the Secretary of Labor discussing workplace injury statistics. what I find interesting is they were looking at the number of occurrences, not necessarily the severity of illness or injury, but just the number of injuries. And the healthcare and public sector workers were getting hurt at work, at a considerably higher rate than any other industry. Just very interesting. So you're talking about people in the healthcare industry, you're talking about people who work in nursing homes, people who work in hospitals, people who work in doctors' offices, clinics, I guess paramedics and things like that. They have the highest incident rate of any industry that's out there. Now, I don't know if their incident rates are the highest in severity. Obviously, if you have somebody that twists their ankle and needs to have some attention to have their ankle dealt with and ends up in a splint for a few days, is significantly different than somebody falling off of a building to their death. Or serious injury where they're hospitalized for months and months to overcome serious injuries from a severe accident in either construction or manufacturing. I just find it pretty interesting that that's an area of concern for the people at OSHA. All right, what else do I have highlighted in this chapter? It's hard to see under this lighting. All right, other things. All right, passage of OSHA was 1970. Since the passage of OSHA, workplace deaths have fallen nearly 65%, and occupational injury and illness rates have dropped 67%. So OSHA has been a tremendous success, requiring safety in the workplace. If you think about the companies that are out there, there are the United States economy, the commerce that we have is broken up into, it can be broken up into many different categories. You've got Fortune 500 companies that they would understand that it's not to their advantage to run a dangerous workplace, that they would want to have a safe workplace because they understand that if your employees are hurt, they're not going to be at work, you're going to lose their production, you're going to lose their efficiency. If somebody is hurt, then you have to pay for their medical care and for their lost wages and things like that. So, the legitimate companies are doing what they should for safety. That's not always been the case. Now, if you go back into the early 1900s, the larger corporations knew that they could hide behind, we talked about this in workers' compensation, hide behind the defenses of contributory negligence and assumption of the risk. So they didn't care about making their workplace safer. They just washed their hands of somebody who was injured at work and hired another one of the people that was standing outside the gate begging for work. Not the case today. But consider the other types of employers that are out there. Most of the people who are employed in the United States are not employed by Fortune 500 companies. They are employed by small to medium-sized companies. Okay, those small to medium-sized companies, what is their position on safety? What is their position on how much money they should spend trying to keep their workers as safe as possible? If you didn't have OSHA, would those smaller companies be trying to take shortcuts to try and create additional profits? Yes, you're going to work slower on a roof if you're wearing a harness. But if you take off the harness, you can get more work done, and theoretically it improves your profit because you can get more work done in a shorter period of time. But you're creating an unsafe work environment. You have to think that through. Are those types of employers out there? Yes, they are. Is it the great majority of people? No, I would think that most people are concerned about their employees and don't want their employees to be harmed. But there are plenty of companies out there that would love to cut corners and make that extra dollar. Unethical companies that would put profit ahead of employee safety and health. So OSHA needs to exist, right? It needs to be there in order to have a standard. I always talk about, if you think about government regulation, and we could bring Giannini into this discussion, and we could talk about the economics of this and the free enterprise system, and the invisible hand theory of allocation of resources and such. The laissez-faire free enterprise economic system believes that you will end up with the most efficient use of resources and the lowest prices because of competition. But one of the things that happens is, if you need to do something for public welfare and it's not going to be profitable for the company, it won't happen. So the public welfare won't occur. The example that you would have there is pollution. So if I'm in a company that in my manufacturing process creates a certain amount of pollution, and I have 5 competitors and we all do business the exact same way, and we're all polluting at the same level, if I make the determination that I want to be a greener company, and I want to cut down on my emissions, and I want to cut down on my greenhouse gases, and I want to be less of a polluter, I can invest in technology to make that happen. However, that investment in technology is going to cost me money. My competitors did not share my my issues with wanting to be a cleaner company. So therefore, I'm not making the most efficient uses of the resources, because I've now taken on additional costs and additional processes in order to make my product cleaner as opposed to cheaper. I'm going to have a competitive disadvantage against my competitors unless I have enough people that say, no, I'm going to pay the extra money because I know Gomolchek is a cleaner company. But people tend to vote with their pocketbook, and people tend to vote for the cheapest alternative whenever they can. So if we didn't have anti-pollution laws, I think you'd be able to see the air. I like the fact that where I live, the air is invisible, except for today, it's got all that snow in it. But I want my air to be colorless and odorless. If we didn't have the anti-pollution rules that we have, I'm sure we could see the air. There are certain places in the country you can still do that. The smog in Los Angeles. In the old days, the air in Pittsburgh was thick with soot from the steel mills and such. But the government had to step in to create the anti-pollution controls. The same thing with safety. Okay, safety is something that we want as a society. We want everybody to have the ability, the right to be able to go to work without having to worry about whether they were going to die today, okay, or be injured today. So safety is another one of those things. Is it costing me money to put in place safety procedures? Yes, it is. It costs me money to maintain first aid kits. Yes, it does. All of those little things. Because OSHA exists, because OSHA insists on companies complying with the safety rules, we have safety in the workplace. There you go. There's your statistic right on page 2 of this chapter in your textbook. Since 1970, the workplace deaths are down 65%, and overall workplace injuries and health issues have gone down by 67%. Those 2 numbers are relatively close. And that's a tremendous improvement in the safety of being at work. So I think that just by pointing at those numbers, that OSHA can certainly say that it's been a success in creating a safer workplace. Completely safe? No. You do read about people being killed on the job a lot. It still happens. What happens? Why did the person die? Because somebody screwed up. There was a safety procedure that was ignored. Okay, the companies, they do their best. If they qualify, if they try to comply with OSHA, they have as safe a workplace as they can, but something may happen. For example, someone gets killed in a manufacturing plant because the guy who was driving the forklift runs him over, hits him, and kills him. Okay, were there procedures that were required to be complied with by the by the forklift driver? Absolutely. If he complied with those rules regarding visibility and line of sight, if he couldn't see past the load that he was carrying, he would need a spotter to make sure that that he was going in the right place and there was nobody that's going to be in the path and be struck by the forklift. If those things were followed, it's unlikely that somebody would have died. But by that person that day deciding to not follow the OSHA rules, someone died. Okay. Somebody dies in an industrial accident because they get sucked into some sort of a dangerous manufacturing machine. There are safety features on every machine. You can't operate the machine, so I always like to give the story on my workers' comp discussions about the guy who loses 2 hands at the axe making factory. Couldn't do that today, because if you had a machine that was going to cut or crush or mold metal, and you were the operator, and you have to put that metal slug into the machine before the big pressure thing comes down and tries to crush and squeeze and shape that piece of metal. Normally you would have a machine that would require you to have 2 hands on the controls before the machine would begin to work. Because if you are holding a lever with your right hand and holding a lever with your left hand, you can't have your hand in the machine, can you? Okay, those types of things, or gates that come down to keep you from putting your hand inside of a machine when something dangerous is happening inside that machine. People sometimes get sucked into the machines or have their hands cut off or whatever it is. How does that happen? Did somebody disable the safety features because they wanted to do things quicker? That's possible. Was there a defect, a flaw in the safety feature that allowed the person to do the unsafe act? Yes, could happen, but it happens. Accidents do happen. We're never going to have 100% safe workplace, but if the only time somebody gets hurt is if somebody completely ignores the rules, or if there is a breakdown in the safety features of a machine, then that means it's going to be a very rare occasion that somebody gets hurt like that. Okay. So those are good things. Those are very good things. Inspection activity. As I said, one of the ways that OSHA makes companies comply with the rule is by going out on inspections. So they have agents that are in the field that are very well versed in what the OSHA rules and laws are. And they go out into the field to do inspections of employers to see how well they are maintaining or complying with ERISA, not ERISA, with OSHA. And there's a chart in your book on page 657, and just looking at it, they have several different years that they have in line here: 2009, 2010, 11, 12, and 13. And they have various things here. We have total inspections, total programmed inspections, total unprogrammed inspections, fatality investigation, complaints, referrals, other unprogrammed inspections. Okay, so total inspections, if you look at those numbers, 2009, there were 39,000, 2010, 40,000, 2011, 40,000, 2012, 40,000, 2013, 39,000. So we're talking about a lot of inspections, 40, basically averaging around 40,000 inspections every year.
Hey, Professor.
Yeah.
So who gets in trouble? Say OSHA was to come and do an inspection or whatnot.
Mm-hmm.
Who would get in trouble if there are safety guidelines put into place, but the employees are being negligent for them? Does that still would they still fine the company or fine the actual individual?
They would fine the company, because it's the company's job to make sure that all of the safety requirements are being met. And that's what that's what the floor level management is all about. Make sure the employees are doing their job, try to keep productivity up and such, but it's also that level of management's job to make sure that the safety rules are being followed. So yeah,
are there any situations where they could fine an individual?
I don't think OSHA has the ability to fine an individual, but obviously the individual would have the opportunity to be fired, fined, suspended, disciplined by the company. So you've got those types of situations. Just continuing down, programmed inspections, I believe. What are programmed inspections? Programmed inspections, I believe, are inspections that are just part of their normal routine, so that they want, they're going to come in, they're going to schedule to come in and do an inspection of a company. So you're looking at between 24 and 22,000 programmed inspections per year. Unprogrammed inspections are employee complaints, injuries, and other referrals. So unprogrammed inspections is where OSHA is responding to a complaint or a belief that there is a problem. If you had somebody who was seriously injured, obviously if somebody gets a cut and needs to have some stitches, OSHA's probably not going to come in and investigate that. Somebody loses an arm, somebody is permanently disabled. OSHA is going to come and probably inspect to see why serious injury happened at your facility. So looking at that, a low of 14,000 and a high of 17,000. Inspections of fatality investigations. 836, 830, 851, 900, 826. I'll be very honest with you, though, that means that every time somebody died and OSHA was required to come and investigate the death as far as the safety features, I think that those numbers are not bad at all, although there should not be, nobody should die at work. I don't think anybody should have a job that they think that they have a chance of dying at, but there are some jobs that are more dangerous than others. And if you look at the fact that OSHA is doing 40,000 inspections a year, and only 800 of them are basically because of a fatality at work, that's not terrible. Yeah, okay, I'm sorry, I understand 800 or 900 people dying per year at their job is not good, but accidents do happen, and myself, I'm impressed that it's not a higher number. Maybe it's too consistent a number is the problem. 836, 830, 851, 900, 826. It doesn't seem to be getting better. Ideally you'd want to see it slipping down into the 700s, and that would show some improvement. It's a consistent number, and I guess if you had a complaint about it, that's what it would be. Specific complaints that they responded to: 6,600, 8,000, 8,700, 9,500, 9,500. So these are whistleblower type situations where you had somebody in the company who said, hey, I think that this is a safety issue, and they contacted OSHA and had them come in and do an inspection. Other referrals: 4,300, 4,600, 4,700, 4,800, 4,000. Other unprogrammed, which let's see, that's includes fatality, catastrophe, monitoring, follow-up, unprogrammed related, unprogrammed other inspections: 2,800, 2,700, 2,800, 2,500, 2,700. The numbers seem consistent, and I guess if there was any criticism of OSHA at this point, is that those numbers are remaining too consistent. If we were making progress and making the workplace safer, we would expect those numbers to start trending down, and it doesn't appear that that's happening, at least with the 4 or 5 years that we have available to us here. Violations: OSHA violations for the same period of time, 2009 to 2013. Total violations: 87,000, 96,000, 85,000, 78,000, 78,000. That's a lot of violations. So even though we had 40,000 inspections, we've got almost 90,000 violations. Does that mean that every inspection finds at least 2 or 3 violations? I don't know. Serious violations, 67,000, 74,000, 62,000, 57,000, 58,000. So maybe that does appear to be trending down. We'd need more years of information to be confident of that. But serious violations, there's a lot of them every year. Willful violations, 401. 1,519, 594, 423, 319. So we have an average of around 400 or so every year, except for 2010, we have 1,500. There is an asterisk. It should be noted that the significant increase in willful violations for fiscal year 2010 is due to a number of significant enforcement actions in the refinery industry, including an action against British Petroleum North America, which has been substantially subsequently settled. So for whatever reason, that year, it appears that OSHA was kind of earmarking the petroleum and refining and drilling industry to try and enforce safety regulations. Once again, certain jobs are a lot more dangerous than others. When I was in the business world before I became a lawyer, when I was an accountant, I had two manufacturing jobs. I had an accounting job in two different manufacturing companies. One was a company called Coca-Cola Bottling, the Erie Coca-Cola Bottling Company. And obviously what they did was they bottled Coca-Cola. We got bottles, put them into our assembly machine or our machine. It would sterilize the machines. It would dry them. It would fill them. It would cap them. And we had people that ran these machines. And I thought I was, big time. I worked in manufacturing, and I would go out into the plant, and I would, put on my hard hat and my safety glasses, and I would go out there and I would watch what was going on because I was interested in what was going on. The next manufacturing job that I had was with a company called Ridgerack. And Ridgerack manufactured industrial shelving. They were one of the world's largest and most complete industrial shelving company. For example, if you go into like a Sam's Club or something like that, you see the forest green, heavy, thick rack with the orange connectors that are holding the shelves onto the vertical. That's them. They made those. I would go out into the manufacturing plant, and the machines that they had there, they weren't spinning machines that were filling glass bottles full of soft drink. They had these massive machines that would unroll rolls of steel, flatten them out into sheets of steel, shear them into sizes, cut them into strips, poke holes in them, and then bend them into shapes. I didn't go out into the manufacturing part of the plant very often, only when I had to track down one of the big managers that I needed to talk to about an accounting issue. I didn't enjoy going back there because that just seemed so very dangerous. Over at Coca-Cola, yeah, I guess I could get run over by a forklift. Over in at Ridgerack, they had machines that would cut you to pieces and not even think twice about it. It was a different thing. So some jobs are significantly more dangerous than other jobs. All right, criminal referrals. OSHA continues to make referrals and provide significant aid to prosecutors addressing OSHA-related matters. Title 29 of the U.S. Code for employees' death caused by willful conduct in violation of OSHA standards, obstruction of justice, aiding state and local investigations, and prosecutors on safety and health-related matters, fraud-related matters, training card fraud also included. So those are the things. They can do criminal charges against you also. I think I said that earlier. Policy and purposes of OSHA, there are two broad goals. One, to ensure safe and healthful working conditions for working men and women. The second one is to provide a framework for research, education, training, and information in the field of occupational safety and health. Okay, OSHA applies to almost everybody. If you are a company that is engaged in interstate commerce, in order to have the federal government have the power to regulate you, you have to be involved in interstate commerce. Keep in mind, the federal government defines interstate commerce differently than most of us would. So most companies are going to end up being covered by OSHA. But if you are not, if you are a small enough company and you don't engage in interstate commerce, rest assured that your state probably has a law that is worded very, very similar to OSHA. It does not apply to federal and state and governments and their capacity as employers, nor does it apply to domestic servants or self-employed persons. So I can be as dangerous as I want in my own business that I do for myself. All right. 3 federal agencies were created under the Occupational Safety and Health Act. The first one is OSHA itself, the Occupational Safety and Health Administration. They're the ones who set the rules and enforce the rules, okay? The second one is the National Institute of Occupational Safety and Health, NIOSH, N-I-O-S-H. This is the part of the of OSHA that is for research into trying to find a way of making the safest workplace possible. And then the third agency that's created is the Occupational Safety and Health Review Commission, OSHRC, OSHRC, quasi-judicial agency created to adjudicate contested enforcement actions of OSHA. Where OSHA may issue citations and recommend penalties, it's OSHRC, which actually assesses and enforces the penalties. Okay, so although people may say, oh, OSHA fined me, OSHA did this, OSHA did that, OSHA inspected, recommended to OSHRC, and then OSHRC is the agency that is actually trying to punish you. Okay. All right. When OSHA is acting, it has the ability, the power to promulgate rules and regulations. Now, this is an agency of the federal government. And once again, if you took business law from me, we had talked about government agencies. This is what's called administrative law. This is where we have the function of government being administered by an agency of that government. For example, Internal Revenue Code taxes us, but the Internal Revenue Service, which is an agency of the federal government, actually enforces those laws. So they collect the tax and penalize people who violate the tax laws, okay? So you have an agency that is created to administer the policy that is created by the law. So in OSHA, we have the ability to promulgate rules, to create rules. An agency's rules have the force of law. Okay, don't misinterpret that. It's not that, oh, well, it's not a statute, so it's not important. No, a regulatory agency has the power to pass regulations, and those regulations do have the power of law. Okay, OSHA has the power to promulgate, to pass or create regulations, and they'll do them in one of 3 standards. There are interim standards, there are permanent standards, and there are emergency standards. Now, interim standards, they exist because we talk about them because they exist in the Enabling Act, the Occupational Safety and Health Act. But interim standards were standards that were created in 1970 at the very beginning of OSHA. Those are the interim standards are those that the Secretary of Labor had power to issue for the first 2 years following the effective date of the act. So during the first 2 years, 1970 to 71, 71 to 72, the Secretary of Labor had the power to just create rules. I guess, you know, at this point, common sense things that everybody should have been doing all along. The difference here is that in order to promulgate rules, there's a very specific and complicated procedure to promulgate rules. These rules that were promulgated during the first 2 years under this interim standard, they didn't require all of the complicated process. They were just put into place by the Secretary of Labor and have become permanent regulations, which is the next one. Permanent standards are both newly created standards and revised interim standards. developed by OSHA and NIOSH, frequently based on suggestions made by interested parties such as employers, employees, states, and other political subdivisions, and labor unions. Okay, you know, labor unions are not a bad guy in this particular situation. The labor unions are out there not necessarily trying to, you know, to bankrupt the companies. They're out there trying to keep their members safe. So this is one of those situations where if you are talking about the inclusion of labor unions in this group of people that can influence OSHA regulations, it's probably a good thing. Okay. Now, in order for there to be a permanent standard, okay, here's how it has to be done. Okay, after OSHA has developed a proposed rule that promulgates, modifies, or revokes an occupational safety standard, the secretary must publish a notice in the Federal Register. Included in this notice must be a statement for the reasons adopting a new standard, changing a standard, or revoking a standard. Interested parties are then allowed for 30 days after the publication to submit written data, objections, or comments related to the proposed standards. If the interested party files written objections and requests a public hearing considering these objections, the secretary must publish a notice in the Federal Register specifying the time and place of the hearing and the standard to which the objection has been filed. Within 60 days after the expiration of the period for commenting, or the first 30 days, or after the completion of any hearing, the secretary must issue a rule promulgating, modifying, or revoking the standard, or make a determination that the rule should not be issued. If adopted, the rule must state its effective date. This date must ensure a sufficient period for affected employers and employees to be informed of the existence of the standard and to its terms. Okay, so there's a process. We have to determine that we need a rule. Then the Secretary of Labor has to propose a rule. Then that proposed rule needs to be published in the Federal Register. And then there has to be a 30-day period for people to comment or make complaints or object. If somebody does complain or object during that 30-day period and requests a hearing, then a hearing will be set by OSHA and the Secretary of Labor. After that hearing has been held, the Secretary of Labor will either decide that the objection was valid or not valid. And at the end of the period, which is another 60 days, the Secretary is required to either decide to revoke the rule, they don't want it anymore, to revise the rule, or to promulgate a final rule. Then that final rule, it doesn't say it in here, but will be published again in the Federal Register, along with the official date, which is prospective in time. It's going to be some point in the future this rule will become effective. Okay. Under certain circumstances, the Secretary of Labor can issue a temporary emergency standard. These standards are issued when the Secretary believes the employees are exposed to grave dangers from substances or agencies determined to be toxic or physically harmful. Actual injury does not have to occur before an emergency standard can be promulgated, although there must be a genuine, serious emergency. Emergency standards take effect immediately upon publication in the Federal Register. After publication, the Secretary must then follow the procedures for formally adopting a permanent standard: publication, 30 days comment period, 60-day waiting period, promulgation and publication of the final regulation. That new standard must be issued within 6 months of the emergency standard. Okay. Now, let's talk about current events. Because this is one of those interesting areas of the law that it was interesting to watch happen. Now, I'm personally somebody who believes that COVID exists and COVID is dangerous, and I don't want to get COVID. I have a son who has particular medical problems. If he would get COVID, we would end up in a situation that is very dangerous and deadly. So I'm very much in favor of vaccinations and complying with whatever safety features or standards are requested to try and avoid contracting the coronavirus. That being said, so you know my position, I found it very interesting to see how the current administration, President Biden, was trying to enforce the mandate that everybody be vaccinated. Personally, once again, if you want to know my political feelings, I do believe everybody should be vaccinated unless you can prove that the vaccine would itself be harmful to you. To you, not in general. You have a philosophical difference, but no, if you have a physical issue that it would harm you, then you shouldn't be required to take it. But beyond that, I think for public good, you should be required to take it. My political beliefs. Okay. So I was watching with great interest when President Biden issued a executive order ordering OSHA to take over the responsibility for mandating that all employees be vaccinated. Okay. Now that was one way of trying to really expand the group of people that was being that would be required to have the vaccinations against the coronavirus, because as we said just a little while ago, the OSHA covers nearly everybody. Okay, nearly everybody. So if OSHA included in its rules that all employers are required all employers are required to require that their employees be vaccinated against the coronavirus, that would have been an extraordinarily high percentage, at least of the workforce. Okay. Of course, that executive order was challenged in the court system. And I believe the most recent thing that happened was the United States Supreme Court, with a very limited opinion, rejected the executive order, saying that OSHA was not required to enforce that. So the executive order making OSHA responsible for vaccinations doesn't exist because it was struck down by the Supreme Court. Wasn't struck down as being unconstitutional, although the court was very, very quiet in its reasoning. Usually the Supreme Court will give a dozens of pages of legal reasoning as to why they strike something down. Suspiciously quiet as to this particular decision. But I believe the decision was based on the fact that these rules for how you promulgate a rule were not followed. Okay, it was done through an executive order from the president. It wasn't done through this process of trying to promulgate rules by the Secretary of Labor. Now, I wonder if they would take the tack of having the Secretary of Labor decide to go through the process, publish a rule that OSHA needs to be in charge of making sure that everybody gets their coronavirus vaccines and is fully vaccinated before they're allowed to work, go through the 30-day comment period, hold whatever hearings are necessary on the back end of that, go through the 60-day period, and then adopt a permanent regulation. I wonder if that might stand. I don't know. I don't know. It's, sometimes in the legal profession, as I said before, sometimes you look at the history of what's going on, and although in a vacuum, what you see happening in the law may appear to be confusing, it makes a lot more sense when you look at what's going on in society at that time. Right now, we have quite a divisive society with people, relatively equal numbers on each side of every issue. So we have a very divisive society and country right now. So 20, 30 years from now, when we look back on this period of time and we look at just the rules and the regulations and the laws and the court decisions, they may not make sense in the broad scheme of things, but they do make sense based on what kind of society that we're in right now. I'm sorry that happens. I do believe, and I had a tremendous amount of confidence that the system would work itself out properly, but I'm not so convinced that it works right now. So maybe we need some improvements. I don't know. End of my little political talk for the day. If you wanted to appeal a standard, you could appeal a standard. If you wanted to ask for a variance from a standard, you have the ability to ask for a variance if for whatever reason you were unable to comply with a standard. If an employer or class of employers believe that OSHA standard is inappropriate to its particular situation, an exemption or variance may be sought. The variance may be temporary or permanent. The temporary variance could be granted when the employer is unable to comply with the standard by its effective date because of the unavailability of professional or technological personnel or of materials or equipment necessary to come into compliance with the standard. I'd like to comply, but the technology at this point does not exist. Once it does exist, once the machinery or equipment is available, I will comply at that time. So you would get a temporary variance. It can be a period for, it can be available for up to 1 year with the possibility of 2 6-month extensions. A permanent variance is granted when the employer establishes by a preponderance of the evidence, that's more likely than not, that its particular procedures provide as safe and healthful workplace as the OSHA standard would provide. So I have my own procedure for doing this. I would prefer to use my procedure as opposed to the OSHA procedure. So therefore, if you can prove that to OSHA, then they'll let you use your procedure instead of theirs, and it would be a permanent variance. Okay. All right, now let me see something here. All right, I didn't think I took attendance, so let's take attendance just so I can make sure that I have that done. All right, Holly Barna, I saw you were out there.
I'm
Marlon,
here.
yep, Marlon, I think you're out there.
Yes, sir. I'm here.
Okay, Madeline De Palma. Madeline, you out there? Not today? Okay. Emily Grandy.
Here.
All right, Colton, you're here. You were talking to me before. Seyon Huang.
Here.
All right. Kayla Jewell.
Here.
All right. Salam, I know you're out there. I always look for your name because I know your microphone doesn't work. I'm going to buy you a microphone one day, I think. Madison Neely.
Here.
Okay. Catherine Sollers.
Here.
Hallie Vogt. Hallie? No, not today.
Here.
Oh, there you are. Autumn Wanchuk.
I'm here.
All right. Andre Williams. I saw Andre when you checked in. Ashley Wolford. I think Ashley's
Here.
there. Yeah, I thought so. And Natalie, you and I talked earlier, so you're here. All right, that's attendance. All right, so continuing right along in our chapter on OSHA, what about employee rights? What kind of rights are available to the employee under OSHA? Okay, so there's a couple of them that I really want to talk about with reference to OSHA. One of which is your right to report your employer to OSHA if you believe that your employer is acting in an unsafe manner. Okay, remember the whole idea behind OSHA is that we end up with a workplace that is going to be as safe as possible. OSHA standards are out there and regulations are out there for the purpose of creating the safe workplace. If you turn in your employer, I believe that there's something unsafe going on here, and I want to report my employer. So you call I'm sure there's some sort of a hotline that you can call to get a hold of somebody at OSHA to make a complaint like that. If OSHA believes that it is something that is indeed a safety violation, then they'll do one of those unprogrammed inspections and come to your place of employment and do a look around, see, are we indeed safe or are we indeed unsafe? How happy is your employer going to be? Because see, there's nothing like an OSHA visit. Employers generally don't like OSHA to come in and make waves. They consider OSHA to be pretty much a pain that they have to tolerate. Nobody welcomes OSHA in because there's always this belief that OSHA is there to find problems, not to fix problems. They believe that OSHA is looking to find those little picayune things. Oh, you don't have a label on that fuse box that says danger or danger of electric shock or electrocution or death. And so we're going to fine you $10,000 because there was a sticker that somebody peeled off that you didn't notice. That's what all employers feel about OSHA. Oh, they're here to cause trouble. OSHA, of course, looks at their job as being, we're here to prevent troubles. But what do you think the employer's feelings are when they find out that an employer has turned them in, that has, ratted them out to OSHA? Hey, you got to come in and see what they're doing here. Yeah. They're not happy, are they? Do you think that on occasion the employer takes negative action against the employee for doing an OSHA whistleblower type activity? Hey, I turned you in because I thought that was an unsafe act. Oh, great. Now you're fired. Can they do that? What do you think? Can the employer fire somebody because they reported an unsafe act to the OSHA? Let's say that the employee thought that it was something that was unsafe. OSHA comes in and investigates, and it turns out that OSHA said, no, that's okay. That is permitted under our regulations. So now you have an employee that caused there to be an OSHA inspection that ended up not being a safety feature, a safety flaw at all. Can the employer fire that person? No.
I don't think so.
No, generally, almost all of these types of laws, you're right, Andre, almost all of these types of laws have whistleblower protections in them. So if you believe, they really want to encourage people to report if they see something. There's no way that this is ever going to be effective if people are afraid to report safety violations. So there is whistleblower protection. No person shall discharge or in any manner discriminate against any employee because such employee has filed any complaint or instituted or caused to be instituted any proceeding under or related to this act, or has testified or is about to testify in any such proceeding, or because the exercise by such employee on behalf of himself or others or any right afforded by this act. So no discharge or in any manner discriminate against any employee. So I can't give you a worse shift. I can't cut your pay. I can't cut your hours. I can't fire you. Okay, so every statute, every enforcement statute like this will have whistleblower protections. What else do I want to talk about? There's a discussion in here about how an employee can make a claim that they have been discriminated against because of a OSHA reporting. You can look through that if you want. Let's see. Yeah, it talks about the procedure. I'm not really that interested in going through that in any depth. In addition to procedures, oh, I like this one. In addition to protecting employees against retaliation, OSHA also gives employees the right to refuse to work in the face of a dangerous condition. Okay, so now this is an interesting question here. Okay, your boss says, hey, I want you to go over and I want you to do that. And you look at that and you go, that ain't safe. I will not do that. Okay, so this is not you turning them in because you believe that there's unsafe acts going on in the company. This is you directly refusing to do something that your boss requests or orders. You're directly refusing a direct order from your supervisor. No, I won't do that. That looks dangerous. I don't have any desire to be hurt or killed today. I won't do that. Okay, so what happens if you refuse to do something that you believe is dangerous. Pursuant to Section 11C1, the Secretary of Labor has adopted a regulation that protects employees from discrimination because they refuse to work in the face of a dangerous condition. The right to refuse can be exercised when employees are exposed to a dangerous condition posing the risk of serious injury or death, and where there is an insufficient time due to the nature of the hazard to resort to the regulatory statutory procedures for enforcement. So it's not a situation where you have the ability to call up OSHA and say, hey, I think there's some bad stuff going on here. This is a situation where your boss is asking you to do an act right now that you believe is harmful to you. You have the right to refuse that. Let's see, what else does it say here? The dangerous condition triggering the employee's refusal must be of such a nature that a reasonable person under the circumstances facing the employees would conclude that there is a real danger of death or serious injury. Okay. And you have to be kind of careful here, because if you end up on the wrong side of this, you may end up losing your job. So you better be darn sure before you specifically refuse to do something. There's a case which is about 3 pages long that's reproduced in your textbook beginning on page 667. This is Herbert versus Altimeter, Inc. This is a company, a trucking company, that hired a driver. It was a woman driver that has nothing to do with it. But this driver was qualified, had the appropriate license in order to operate the type of vehicle that this trucking company used. Once they hired her and she had gone through all of the paperwork, got her physical to prove that she was able to drive, they issued her a truck to be hers to use while they're doing, while working for them. She was making her deliveries and decided that there was a problem with the exhaust on the truck, and she believed that she was getting carbon monoxide poisoning by driving the truck. People in the trucking industry, sometimes they have, it can be kind of an informal thing inside the truck. You could take somebody along with you, your husband or wife. This woman had a dog that she took along with her on her trips. And she noticed that her dog was becoming lethargic from riding in the truck, that she'd never seen this before, and thought that it was a health issue to the dog. The woman herself started experiencing nausea and headaches, which are indeed symptoms of carbon monoxide poisoning. She reported to the company that she believed that the truck had an exhaust leak and needed to be repaired. The company did some repairs, sent her back out on the road. She continued to have the symptoms and her dog continued to be lethargic. She reported again that she believed that there were exhaust problems with this truck. So they took the truck off the line and told her to stop driving while they inspected the truck. They took it to a dealer, a certified mechanic that looked over all of the exhaust systems and whatnot, made a few repairs. They took the truck to a local fire department that had a carbon monoxide meter and ran the truck with the carbon monoxide meter in the truck, which showed no carbon monoxide in the truck, issued her a new truck, and then eventually decided to fire her. They said that it was because of her attitude, that it was because of her inability to meet the goals and requirements. She said that she believed that she was let go because of her refusing to want to drive the truck that was causing health concerns. Obviously, driving a truck that leaked carbon monoxide into the cabin was indeed a health concern covered by OSHA. So her being fired, she took as being a discriminatory act, removing her from employment because of her refusal to work in an unsafe working condition. Okay, now the case itself doesn't get sorted out real well because what happens at the very first level of hearing is that the hearing officer throws the case out and just grants what's called a summary judgment in favor of the company, saying that there was absolutely no case that the plaintiff, the woman, could bring, that she was completely wrong and they didn't even have to hear any of the arguments. She appealed this to, what court is this? Let me see. She appealed this to, it appears that it's the Federal Appellate Court or the Intermediate Appellate Court of the federal system. She appeals it to that Federal Appellate Court, which then finds that the issuing of the summary judgment by the lower court was improper. That although that it's possible that a jury would have found in favor of the defendant, that it was completely improper to take the case away from the jury and issue a summary judgment. That it was possible that a jury could find in favor of the driver that she indeed did have those medical problems. As a matter of fact, one of the things she had done was she had blood work done when she was in the middle of having the biggest problems with the symptoms. And then she had another blood test done after she had not been driving for 4 weeks or something like that. According to the facts here, they showed that her carbon monoxide levels had gone down dramatically during the period of time she wasn't driving. So there certainly was enough evidence to possibly show that she should have been able to make the OSHA claim. So all that happens, we don't have the ultimate decision here, is it goes back to a lower court to be heard and presented to a jury again. I'm guessing that we don't have a resolution here because it never made it to the second trial. Somebody decided to settle out of court, and that becomes the end of it. So we don't have a good answer in the court system. All right, I've run out of time. It's almost 10 minutes to 4. On Tuesday, we will finish this chapter, and this is the last chapter in the first grouping of materials. So we'll end up having a test after we complete this chapter 20. Keeping in mind that I believe that I will be back on campus next week. Starting on Monday, I'll have my office hours from 10:30 to 2:30. So anybody that needs anything from me, wants to stop by and say hi, whatever, I should be in my office, AC 30. Class will be held in our normal classroom, AC 40. That's the big classroom in the lower level of the academic center, starting at our normal time of 2:30. But we'll be face-to-face in person unless something comes up either on my personal life or the school decides to cancel again because yet another snowstorm decides to come through. But all things being equal, I expect to see you guys. It'll be the first time in the classroom for me this semester. I'm looking forward to coming back and seeing you. Any questions? If no questions, that's all I have for today, and we'll see you on Tuesday then.